All right, welcome back to my BADM 107 students, and now we're going to dive into the lecture material. There's a number of ways you can do this. You can put my lecture guide up on the screen and just listen to my voice in the background, or you can split your screen so that you can see the lecture guide and my bobbing head. Or the third thing you can do is you can actually print off the lecture guide, watch my bobbing head, and take notes. However, it is important to take notes because the first thing you want to do is you want to go to slide 2 on my lecture guide. And as I mentioned in the introductory lecture, because I'm a lawyer, because I have practiced law, and because you may ask a question that requires a legal answer, we have to put in a warning. And so I've got the warning: neither the materials nor the lectures or comments made by your instructor in class are intended to be legal advice for specific legal problems. Students with legal problems are advised to consult legal counsel. Okay, and then also just above that warning, there is a note which says that the lecture guide is well, let me put it this way: it's my idiot's guide. Not that you're the idiot, I'm the idiot. If I don't have a guide and I don't follow it as I lecture, I'm going to miss materials. I'll think I've given it to you, and then on the exam you'll go, hey, where's this coming from? So I follow the lecture guide. However, the lecture guide is not intended to be notes for the course. Now, it cuts down the amount of note-taking you have to have, but you are still supposed to take notes and fill in blanks, okay? All right, the slide number 3 is a picture of the goddess Themis. I had the pleasure of going to Athens pre-COVID-19, thank goodness, and I went to the Acropolis Museum, had that picture of the Greek goddess, and I found it interesting because it has the scales of justice, obviously indicating that justice will be done, and Themis is holding a sword, which means that she's going to punish you if you break the law. That reflects the belief of the legal systems in the past. However, if you look in the lecture materials, which you bought for a nominal sum at the bookstore, hopefully, or should soon, at the beginning there's a picture of the goddess Themis from our courthouse downtown, the Supreme Courthouse on Smythe Street. Beautiful statue, and there she is holding the scales of justice, but instead of holding a sword, she's holding a scroll, which I think is indicative of punishment being less severe these days than in the past, and whether you believe it should or shouldn't be is a topic for a theology course. But it does show you the difference between those concepts. Now, the first concept we're going to talk about in the course is risk management. As I indicated in the beginning lecture, at least I hope I did also teach in the tourism faculty. They asked me to teach their law course, which they called risk management. This was years ago, and I suddenly thought to myself, well, that's actually what I do as a lawyer. I don't have my client step in the pitfall and then try to save him. What I do is I take a proactive approach and I try to prevent problems from occurring. One of my clients that I'll talk about quite often runs a lodge facility up north in BC and has a number of aircraft, and he flies fishermen and hunters and hikers around the area. And there's all sorts of risks associated with that. And years ago I said, okay, the fellow that runs it is named Urs. He's a Swiss Canadian. And I said, Urs, I think what we should do is we should look at your overall operation, and we should look at the various risks associated with it. You need a waiver of liability for the canoers, hikers, and hunters, etc. You have to have warning labels at places like your float, where your float plane ties up. You have to look at the restaurant operation, all those sorts of things. And so I spent about 5 days up there going through his his operation doing that. And because I realized that risk management is really what I do, I changed the way I taught this course, BADM 107, to reflect that. And I was pleased over the years to see that the old textbook for the course moved from, okay, you've got a legal problem, here's how you solve it, to, okay, here's your operation, let's do risk management to prevent those legal problems. So that was very satisfying to see that I was sort of one step ahead of the textbooks. Now, of course, in the textbook for the course, it does take a risk management approach, and I start off with a section before we even get into Chapter 1 called Risk Management. Risk management involves 4 things: eliminating risk, reducing and managing risk, shifting risk, and retaining risk. So, what's risk? Well, the dictionary has 3 elements to it. The first is the possibility of loss or injury, very particularly important in extreme sports businesses, but applies to all businesses. Reducing and managing risk. There are things you can do to, number 2 is a dangerous element or factor. And so you look at your operation and you find a dangerous element or factor, and then you take steps to mitigate the possibility of a problem. And the third is a chance of loss or the perils to the subject matter, and that relates to insurance. So that's risk management, four elements to it. Looking at element number 1, eliminating risk. Years ago, I had a business idea, and I thought, okay, I'm going to develop that when I have time. And as the years went by, I was so busy, I didn't get a chance to do it. I didn't get a chance to do it. I didn't get a chance to do it. And then when I finally got around to doing it, I thought, all right, business plan. You always start off with a business plan. And I did my business plan, and I realized that technological developments in the marketplace had surpassed my idea to the point where I would be unlikely to make a profit. So I reduced the risk of loss by just not doing the business idea. So a business plan is one thing that you can do in order to eliminate the risk. But inside your operation, there may be elements where you can actually eliminate a risk. Let's say in a manufacturing process, there's one specific piece of the product that is incredibly dangerous to make because of toxins or because of the potential of explosions or something like that. Well, you could say, let's eliminate that risk from our business operation by buying that part from someone else. So there's things you can do. Even in river rafting, for example. My niece was a river rafting guide, and so my wife and I went down the rivers with her on numerous occasions, and we did it twice in 1 year. We did it early in the season, and we were going down the river, and my niece said, okay, we're going to go over to that side of the river and surpass what looked like a rapid. And I asked her why, and she said, well, because at this time of the year, the water level is so high, you cannot discern the actual location of the rocks, and so it would be dangerous to go through that rapid. Later on in that year, we went down that same river, and there was the rapids, and boy, they were going like this, but she knew where the rocks were. And so a risk was eliminated earlier in the year by not doing a certain aspect of a trip. Okay, so that's eliminating risk. Reducing risk or managing risk is really the function of, to a large extent, HR management or operations management, because what you do is in HR is you make sure that you train and license your staff appropriately. Going back to the river rafting example, my niece related to me. She knew the owners of the business really well because she was there from the startup. And as they expanded, they needed guides. And this fellow turns up from Australia and he said, "Oh, good day, mate. My name's so-and-so and I'd like to buy a river rafting guide." And he said, "Have you got a river rafting license?" "Oh, yeah, mate. I've had one in Australia for years." "Have you got your first aid?" "Oh, yes, I've got my first aid certificate. No problem." They said, "Okay, well, you'll have to give those to us before the season starts." "Yeah, no problem, mate. I'll have them send it from Australia." And then as they're preparing for the season, the owners kept saying, "We need your certificate and your first aid proof." And he kept putting them off. "Oh, it's on the way, mate. It's in the mail." And the next thing you know, they're already operating. And the fellow was so personal and seemed to know what he was doing that it wasn't until 2 or 3 weeks into the season when the owner finally came to him and said, "Look, you've got to give me your license and your certificate for first aid." And he said, "Oh, I don't have those." And the owner said, "What?" And he said, "Well, look, mate." He said, "Now you know how good I am, so no problem, eh?" And something happened, and he wasn't properly licensed or didn't have his first aid certificate. The business would have been in serious trouble. So you actually have to make sure that those things are taken care of ahead of time. Okay, that's an extreme sport. I mean, it wouldn't apply to other areas of business, right? No, wrong. I had a client, a Sylvan Learning Center. If you're not familiar with those, it's for students that are struggling at school. They can go to the Sylvan Learning Center and they can have one-on-one or two-on-one instruction from a teacher after school hours or on the weekends or in the evenings. And obviously, when you hire teachers, you have to be incredibly careful that you don't hire somebody that's, for example, a pedophile. Well, the one office manager, he had a number of offices, and one office manager wanted to hire this fellow. And again, he was very personable. And she said, "Well, we're going to have to do a criminal record check on you. Is that okay?" And he said, "Oh, yeah, sure, fine, no problem." So she gave him the form and he signed it. Well, you'd think that somebody that was so willing to sign the form wouldn't have a criminal record. Anyway, she's a very busy person. She said, "Okay, I'll have to do that criminal record check." And she's working. "Okay, I'll have to do that check." "Okay, working. "Oh, I'll have to do that check." Well, the next thing you know, they've hired this person and he's working there. She finally thinks, "Oh, well, I better do it." So she does it, and it turns out he has a record as a pedophile. And now you've got a pedophile working with young students in a private setting after school hours. So it was a terrible problem for him. We had to actually take proper steps to have that person dismissed legally. He couldn't say we lied on his application form because they didn't ask him if he was a pedophile. I just said, "Can we do a records check?" And he said yes. So you have to be very careful about that. But attention to HR management rules go well beyond that. You have a manufacturing process and you hire the lowest common denominator, somebody that you can pay less than minimum wage, and he thinks, "Oh, that's a good salary," right? So not the brightest bulb in the street. Well, they make a mistake. You as the owner of the business will be vicariously liable to pay the damages. Why? Because you were negligent in your hiring or training. So what you have to do is make sure that you hire correctly, that you train your staff, and that you properly supervise them. That will minimize or manage risk during your operation. All right, number 3 on the list is shift risk. A lot can be done in this area. One thing you can do is incorporate your business. Now, in the opening lecture, I talked about how a corporation can be formed to limit your liability. We'll get into that in a big way in Chapter 8. But you want to form a corporation if you have employees and there is a significant risk of them being negligent and causing the business a loss. All right. So what you're doing is you're forming a corporation, which you are the shareholder of, and you're the director of, and you're the officer of, the president or whatever. And there's this corporate veil of protection between you and the corporation, which says if the corporation contracts with somebody, then The contract is between the corporation and that other person or business, and you as the owner, director, and manager have no liability on that contract. So you're shifting the risk from yourself or from your owners to the corporate entity. Another way to shift the risk is through waivers of liability. I was surprised when one of the lawyers teaching at Capilano University said that waivers are totally useless and aren't valid. Because I taught in tourism, because I've had tourist businesses, and because I'm a practicing lawyer, I knew that that statement by him was incorrect. So I subsequently talked to him, of course, and we worked it out. But he didn't have those kinds of businesses. There's no lawyer in the world that doesn't believe that he or she can beat a waiver. But if a business properly drafts a waiver and properly administers a waiver, then that waiver will shift loss, even due to negligence, from the business to the participant. Dyke versus Manitoba Snowmobiles was the first one years and years and years ago, where a participant signed a waiver. He was injured through the negligence of the Snowmobile Association when they were putting on a big contest, and the waiver was upheld and the business was protected. Okay, since then there have been numerous cases going both ways. If you don't draft it correctly, it won't help. If you don't execute it correctly, it won't help. But if you do your due diligence and risk management, then that waiver of liability will shift the loss from the business to the participant. And the third obvious way of shifting the risk is insurance. Okay, you go out and get an insurance policy, let's say for a billion dollars. It doesn't matter how much insurance you get, it will not prevent an accident. An accident is going to happen if it's going to happen. What it does, though, is it shifts the payment or the loss of that accident from the business to the insurance company. Okay, so that's the whole concept of risk management, and that thread will run through the entire course. So, we're now going to Chapter 1, and we're going to spend a particularly long period of time on this for a couple of reasons. Number one is a lot of you are new Canadians, and you may not be familiar with our legal system. And even those who are long-time Canadians hopefully have had no exposure to our legal system. And so this chapter is called the Canadian Legal System, and it starts off with a very obvious beginning point. What is law? And on the lecture guide, which you can read, and I'm going to read it on my screen, the definition is law consists of rules enforceable in courts or in other government agencies. Other government agencies, what would that be? Well, that would be Employment Standards Branch, Labor Relations Board, Workers' Compensation Board, things like that. Purpose of the legal system? Three things. Provide protection of persons and property. All right, so right away we think criminal law. Yes, criminal law is obviously one way that the law provides protection. But the other way is even in a breach of contract situation, which has no criminal aspect at all, it protects us because you have a fair degree of insurance that if you have an enforceable contract and someone breaches it, you will be able to use the legal system to protect your rights, either to get something that was owed to you or get payment for something that was delivered. The second is it provides the government with the power to act for the benefit of society. The government decides to put an ALRT line, another one out to the airport, and it's going to go through your living room. there is no way that you are going to be able to stop that, because we have given authority to our government to allow them to make decisions on our behalf that are for the benefit of society as a whole, which means it may interfere with your individual rights. However, we do have this thing called the rule of law, and this prevents the government from saying, well, the LRT is going to go through your house, I'm expropriating your property and not paying you anything. Okay, because the rule of law, and I'm very big on the rule of law, it's probably going to be on the exam. And I'm just going to read it here. It says, the rule of law is a legal principle that law should govern a nation as opposed to being governed by the decisions of an individual government official. It primarily refers to the influence and authority of law within society, particularly as a constraint upon behavior, including behavior of government offices. Look to the south of us. There's a president who says, my authority is absolute. I can do anything I want. And the United States is in danger of losing the rule of law because of the encroachment on the rule of law by the particular president. But they have a constraint, and it's called the Constitution. In the Constitution, I believe it's Article 10 of the Constitution says that the powers are with the governors of the states, who then grant authority to the federal government to do certain things for all the states. Okay. So, but the rule of law comes from England, and it's extremely important to the basis of the common law and civil law legal systems. Now, the third point is that the law provides us a broader freedom of choice. And this can be something as simple as you may have a certain sexual preference so that you want to live your life differently than what we used to think was the norm. For example, if you are gay, you want to live with another man, and you want to get married. Well, our laws provide us the opportunity to have same-sex marriages. And this means that you have a broader freedom of choice within the society. The law provides that. The other, but it can also be something like you have a business and you want to buy product and sell it on 30, 60, 90-day terms. In other words, you're saying, give me your product and I will sell it. I'll get the money, and then when I get the money, I'll pay for the product plus keep some profit for myself. Well, I would never, ever say, oh, okay, you want product? Okay, pay me 90 days from now, here's the product, if there was no opportunity for me to avail myself of the legal system and sue you if you didn't pay. So it provides us a broader freedom of choice in many, many ways. Okay, now I'm going to get on to the Magna Carta. And there was a joke going around last year and the year before that if you didn't know the answer to any question on my exam, put down the Magna Carta, because Professor Holden loves the Magna Carta, and you'll at least get part marks. The Magna Carta is a legal document signed in England in 1215 by King John, and he gave powers up. Now, Trump thinks that he's an emperor or a king, and that he has absolute power. As he said, he could go down to Fifth Street in New York and shoot somebody, and there's nothing that anybody could do about it. But anyway, back in 1200s, the king had absolute power in England. And he was using it to overtax the populace. And so the barons revolted because the king needed men for his army, and he needed taxes so that he could, go off and have a nice war. And the barons said no, and they marched on London, and they all said, "That's it. You're not getting anything else unless you sign the Magna Carta." And so he signed it, and it was at that time it was called the Great Charter of the Liberties, and he signed it reluctantly. And here is his seal, the seal of the king, which was affixed to the document. Here's a picture of the document on slide 12 with the king's seal at the bottom, and it was attached by a ribbon. So back in those days, they didn't have duplicators, and there were something like 83 barons, and so they had to have a huge number of copies of this. Imagine that, writing out those documents and having them exactly the same, and they were all sealed by the king. And what the king did was, in effect, gave up power. There are only 3 copies of the Magna Carta in existence today, and I went on a pilgrimage. Let's see, about a year and a half ago, my family and I went to England, and everybody wanted to see the Stonehenge, and they wanted to see the Hadrian's Wall, and they wanted to visit London and see a show, and they wanted to look at the White Cliffs of Dover, and they wanted to look at lots of cathedrals, and Buckingham Palace and everything. I wanted to see the Magna Carta, and there are only 3 copies, so I went to the Salisbury Cathedral and saw the Magna Carta, and because I know the significance of it to our legal systems, quite frankly, it almost brought a tear to my eye. My kids joked about that. So here's an actual one that's protected. So it was kind of hard to, and this is slide 14. It was kind of hard, to read, particularly because of the Old English and the handwriting. But that's it. And the next year, by papal bull, the Pope nullified the Magna Carta. And you think, well, they signed the Magna Carta, and it's this important legal document that gives us our freedoms, starts to give us our freedoms, and then the Pope says, no, we're canceling it. Then why is it so important? Well, because it was subsequently amended and re-signed by a subsequent king, and it was amended again and re-signed, taking out certain aspects of it which don't relate to freedoms but related to taxes at that particular point in time. The freedoms remain consistent throughout the versions of the Magna Carta, and that gets down to slide 16, Articles 39 and 40 of the Magna Carta. Now here's the funny thing. When the Magna Carta was written, they didn't put it in paragraph forms and number them and things like that. They just wrote it out. It wasn't until subsequent analysis of the Magna Carta by legal experts that they put in the numbers. So Article 39, for example, says no freeman shall be taken or imprisoned or disseized or exiled in any way destroyed, nor will we go upon him or send upon him except by lawful judgment of his peers or by the law of the land. So what we're saying is there is no incarceration without due process of law. There's no confiscation of property without due process of law. And then Article 40 says, to no one will we sell, to no one will we refuse or delay right or justice. So in other words, you are entitled to your day in court. Okay, decised is yield English for seized. So they're saying we cannot seize your property. And the the Magna Carta was the start of our freedoms, and then after that, we England moved toward, well, judges went out and began making decisions on court cases, and we'll get into that a little later on when we talk about subsequent sections of the Magna Carta. And they went out to make these decisions with 3 knights of the realm in case there had to be punishment, or people incarcerated, whatever. And eventually the courts began to make decisions that the king used to make in the past. And that was the real start of the common law system. Okay, we're going to shift gears now a little bit, and we're going to look at the development of the law from a little bit of a philosophical point of view. And we'll do that by reference to the Regina versus Dudley and Stevens case. And on Moodle, there's a special sheet. I can't remember whether it's 2 or 3 pages long about Dudley and Stevens. And in the past, what we've done in class is I actually chose some students to act as Crown prosecutors, and I chose some students to act as defense counsel, and we would have a little moot court for a number of reasons. Number one is it would introduce us to the court system. It would also be used to demonstrate the difference between natural law and positive law, and it would also show us that law is not a static thing, that it's developed over time. So let me just briefly outline what it was about. Regina versus Dudley and Stevens is what you call a cause of action, all right? And that's explained in the sheet that's on eLearn. Well, Regina versus Dudley and Stevens is the cause of action. That's a term you have to know for the course, and I'll come back to that in a minute. And it gives us some idea of the nature of the case. Is it public law, meaning the government on one side and a person on the other, or is it private law, meaning 2 private persons going after each other? Well, obviously R is Regina. Is that a city in Saskatchewan? Well, yeah, it is. But Regina is also means the Queen. The case can also be referenced as the Queen in right of the United Kingdom versus Dudley and Stevens, or Regina versus Dudley and Stevens, or R versus Dudley and Stevens. So that's the style of cause. If it was Holden versus Graham, then we would know it was private law, because it would be 2 private individuals, because neither of us are the government. The other part, bracket 1884, end of brackets, QBD 273, is the rest of the legal citation. So Regina versus Dudley and Stevens, and that 1884 QBD 273 is called the legal citation. That allows lawyers to find this case if they want to use it as precedent, or look at it to see if the legal argument might help them, and then decide that it isn't appropriate. Well, how do you find the case? I mean, there's millions of cases that have been decided in England and Canada since the inception of the courts. Well, we take this, and QBD, wait a minute, Queen's Bench Division. Now we know that it was the Queen's Bench Division, which is a court system in England. So then we would go to QBD, which is a series of legal books, cases, and we would look for volume, let's see, QBD, it should be 14 QBD. I think that's a typo. I think because it says 14, it means you go to volume 14 of QBD, and then you look at page 273, and bingo, you can actually read the case. So a case starts off with referencing the name of the case, Then sometimes there's what's called a head note, which is the editor's summary of the case, and then you get into the actual judgment itself. Regina versus Dudley and Stevens was a bit of a gruesome case. What happened was a yacht purchased by someone in England from someone in Australia was being sailed back to England, and they went around the tip of South America, and they were coming up, and in the South Atlantic it got caught in a huge storm and the yacht sank. Everyone drowned with the exception of 3 men and a young boy who made it onto a life raft, and that's a picture, a drawing from the London News, which is a newspaper, which shows the size of the life raft that they were in. And it was adrift in 1884. This was a desperate situation for these 3 individuals and that young boy, because they only had a small amount of food, some canned turnips. They were able to catch a turtle that came by and kill it with a knife and drink the blood and eat the meat. And then they were out of food. And this went on for weeks. And they ran out of water, and they collected rainwater, but soon they ran out of rainwater, and things were extremely desperate. So, let's get on the radio. Mayday, mayday, mayday. Well, there are no radios in 1884. Let's put the yellow dye in the water, and the search helicopters that are looking for us will find us. No helicopters in those days, obviously. They didn't have yellow dye in the water, and worse still, nobody's looking for them. When the yacht went down, there was no timetable that said, wait a minute, that yacht was supposed to arrive in London last week, or in Plymouth, last week, and it's not there. We better go look for these people. It was a private yacht, so nobody was looking for them. The odds of being discovered by a ship going by was extremely, it was almost nil. Okay. As things got more and more desperate, the 3 men began to talk about their families and how the families would suffer if they didn't get back to England. In those days, they would be kicked out of whatever house or home they had. They would go to a poor house. They would be living on welfare because there was no social net, no welfare payments from the government, no EI or things like that. And the children of the families would then go to the sweatshops, and they would work from sun up to sundown in appalling conditions just to make a meager amount of money so the families could possibly survive. So it wasn't only desperate for the men on the boat, it was desperate for their families in England. The 3 men talked about the possibility that someone should be put to death to save the lives of the remainders, which was a standard practice in those days, that the sailors in such a situation could legally decide that one of them would be put to death so that the others could feed upon their body to survive. Well, they talked about it. The next day, no ship in sight, the 2 men said, well, maybe it would be better to kill the boy, who was then lying in the bottom of the raft, quite ill. The 3rd man said no, and the other 2 men said, okay, the following day, if there's no vessel in sight, then we'll kill the boy. The following day, the 2 men issued up a prayer for forgiveness, used a knife to kill a boy, and the 3 men fed upon the boy's body. And miraculously, a few days later, they were rescued. Now, they didn't deny that they had killed the boy, because there was this sort of rule of the sea that this could be done. And so when they got back to England, they were astounded to find out that the law had changed and that this was now considered to be murder. And the 2 men, Dudley and Stevens, were taken into custody and charged with murder. the third man was charged with no offense. They didn't deny it, what had happened, and so it was pretty much seemed like an open and shut case. For England, this was a terrible, terrible situation that went well beyond the effect on those people in the family. Because if you think about England at the time, they had a huge empire that was held together by the Merchant Marine and the British Navy. The recruitment just dropped off. It just stopped. People said, whoa, I'm not going to join the Navy, or, oh, hey, I'm not going to become the Merchant Marine, because imagine that, a disaster at sea, and somehow you survive, and you somehow are saved, and you get back to England only to be hanged for murder. So it became a real political football. And we know what happened in court. Because the media was very much involved in this. And so the media were there and they were watching in court. And I like talking about this case because it does also allow me to explain a little bit about what happens in court and how things occur. In our little scenario, we assumed that the facts of the case were as set out in the handout that I've posted to eLearn. And then the Crown prosecutors would start off and they would do a summation, which means the trial is over with the exception of the judge making a judgment. But before that happens, the Crown prosecutors get to stand up and explain to the judge why Dudley and Stephen should be convicted of murder. And then the defense counsel get to stand up and they explain extenuating circumstances and other possible defenses and why these people should be acquitted and allowed to leave. And so the two students would do the Crown prosecutor's position, and then two students would do the defense counsel position, and then I, as the judge, would ask, or would charge the jury, and I'll come back to that. I would ask the rest of the class to serve as the jury and make a decision. Well, in the actual case, during the trial and the bringing in of the evidence, it was very apparent that the judge was sympathetic towards Messrs. Dudley and Stevens. Whenever the defense counsel was talking about possible defenses, the judge was taking notes. And this was not lost on either the media that reported what was happening in the court or on the Crown prosecutors. So what I'd like to do now is take a short break, and then I'll talk about why this note-taking and watching the judge is so important. Okay, so we're just going to take a short break. Okay, back from the break. We were talking about Regina versus Dudley and Stevens, and I was at the point where I wanted to talk about litigation a little bit. I did litigation earlier on in my career, and then as I began to lecture full-time, I found it harder and harder to do that, and so I've discontinued it mostly. But when I was doing litigation, one of the things that I learned was that court cases, it's incredibly important to watch the judge's reaction. I had one really big case, and I have to do a little bit of explaining. I had a client, Richmond Savings Credit Union. This is a public case, so it doesn't matter. I'm not divulging any confidential information. But what happened was, it was back when the banks and the credit unions and the trust companies were battling, because banks were bringing in charges for everything, and the credit unions and trust companies were trying to use that as an advantage in advertising. So Richmond Savings Credit Union came up with this ad campaign. They created a fictitious bank called the Humongous Bank. And they had radio commercials and television commercials where someone would come into the bank and they'd walk up to the teller and they'd say, "Good morning, I'd like to make a deposit." Ding! What was that sound? And the teller would say, "Oh, that's us charging you because you want to make a deposit." "Well, why have you got that?" Ding! What's that? "Well, that's we charge you for asking questions." And it was really funny. And they were charging you for breathing the air in the bank, and they were doing all this sorts of stuff. And then they would say Richmond Savings Credit Union has no charges. They all do now, but back in those days they didn't. So anyway, Richmond Savings Credit Union found this was a very, very powerful ad campaign. And they had a tagline at the end: "We're not a bank, we're better." And that tagline irritated the banks incredibly. Other credit unions and trust companies contacted Richmond Savings Credit Union and said, "Can we use that tagline?" Credit union called me up because I was their legal counsel for marketing and advertising. And they said, "What happens if we let them use it? Is it okay?" "Because they're willing to pay us for it." And I said, "Well, then you'll lose your rights to it. So what you want to do is you actually want to license them to use it. So it would be better to register the trademark and then license them as a registered user, because then it's still your tagline, but they're paying you for it and you can control it. They can't change it." So they said, "Oh, great. Well, go ahead and register it." And I said, "Well, there's a problem there." I said, "If we try to register it, the chartered banks will try to stop you by bringing an opposition because you're using the word bank. Under the Bank Act of Canada, in a section way towards the end, it says you cannot use the word bank, banking, or banker unless you are actually a chartered bank under the Bank Act, not a credit union under a provincial statute or a trust company under a provincial statute or a federal statute." And they said, "Oh, so we'll file and then they'll oppose?" And I said, "Yes." And they said, "Well, what would happen?" And I said, "Well, then there would be a hearing, and they would say you cannot use that, and then you would be fined." And they said, "Wow, that's terrific, because then what we would have is a situation where the big banks are beating up on the little trust company." And they said, "What would happen?" I said, "Well, there would be a hearing, and if I was your legal counsel, then I would be there, and the chartered banks would be there." And they go, "Oh, wow, this is great, because then it's a big law firm beating up on the little law firm, and that's just great for advertising." And so they didn't care whether they won or lost. They said, "Go ahead and try to register the trademark." So we filed the application to register "We're not a bank, we're better." And sure as guns, the Chartered Bankers Association, on behalf of all the chartered banks, registered an opposition. The next step in the process, this isn't like an actual trial where you have witnesses. What happens is both sides provide affidavit evidence. So the Richmond Savings Credit Union would provide an affidavit or two saying why they thought they should be able to register it. And the Canadian Bankers Association would provide affidavits saying why it should not be registrable. So the Chartered Bank, or the Canadian Bankers Association, filed two affidavits. One of their marketing managers, which was terrible, absolutely terrible. It was full of contradictions and not much of a problem. But then they filed the affidavit from a lawyer with the second largest law firm in Canada, which was going to represent the Canadian Bankers Association. And he had impeccable credentials. He was a senior partner. He did banking law. He had written the textbook that law schools use when studying the Bank Act. And so when I got that affidavit, I sort of thought, how do we try to deal with the credentials of that particular situation? So my business manager and I mulled that over for a long period of time, and then we looked at the content of that affidavit, and there were three glaring errors. And those three glaring errors allowed for that affidavit to be questioned.
You're clearing your throat every couple of seconds.
Thank you.
Don't let them hear that you've got one in your mouth.
Sorry for that brief interruption. I'm suffering from the spring allergies. My throat was getting scratchy, and so my wife came in and handed me a cough drop, and I'll suck on that if I have to. And my apologies. When you're making an oral presentation, the last thing you want to do is be sucking on a cough candy or chewing gum or something like that. It's very disruptive. But anyway, I'll do my best. Anyway, where was I? Oh yeah, okay. So we had this affidavit and it had three glaring errors in it. I'll just deal with two of them. But the idea is they file their affidavits and we file our affidavits, and then we question their affiants, the people that made the affidavits, and they question ours. And then those cross-examinations of the affiants is also introduced as evidence. And that's the evidence at trial. And then you get to the stage where you have the summations, okay? Anyway, I looked at the affidavit and I thought to myself, he says that section such of, I think it was 427 of the Bank Act, says that you cannot use the word bank, banking, or banker, and that section had never been judicially interpreted, which means it had never gone to court. It was so clear that, you wouldn't waste time in court. Well, my business manager and I scoured law reports in the law library downtown for hours and hours and hours, way more so than we were going to get paid for, but we were serious about this. And we found a case out of Manitoba that judicially interpreted that section. And it not only judicially interpreted that section, but it interpreted it favorably for my client. And then the other thing was, so when we were cross-examining him, we said, Mr. So-and-so, you state in paragraph such and such of your affidavit that it has never been judicially interpreted. And he's correct. And then we said, well, what about this case? And we handed it to him. And he sort of looked at the case, and looked at me, and looked at the case, and and got really upset because you swear that the contents of the affidavit is true to the best of your ability. So he wasn't lying. He didn't know about the case, so he wasn't lying in his affidavit. But here's the person that should know everything about the Bank Act, and he doesn't know about the case. And it's in favor of our client, not his. So he was... I said, does that interpret the Bank Act? And he said, well, it appears to. I mean, what kind of answer is that? It either does or it doesn't. And it was pretty clear that it did. So he was trying to obfuscate, right? And I said, and what's the decision? Did it say that in certain circumstances the word banker could be used? Well, it appears as though in a roundabout way, blah, 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 blah. And I said, does it or doesn't it? Okay, and finally he said, well, yes, it does, right? So that's a real flaw in his affidavit. And another portion of the affidavit, it said that the Bank Act was so important that it should be given a wide interpretation. So if it says you cannot use the word bank, banking, and banker, even though we're not exactly saying that Richmond Savings Credit Union is a bank, we're just saying they're better, it should be given a wide interpretation to prevent that. And when I was questioning him, we questioned him on the basis that there's a liberal interpretation of statutes, and the Bank Act is a statute, and there's literal interpretations. And a literal interpretation says if you use it, you've contravened the law. And then the liberal interpretation says if it's used in a roundabout way, or it could be interpreted to in certain circumstances. Well, in constitutional matters where it's social intent that's being discussed, they have a liberal interpretation, a wide interpretation. But if it's a criminal statute, it's a literal interpretation. Either you did break the law or you didn't. So he, in his affidavit, said that the Bank Act was almost constitutional. It was so important that it should have a wide interpretation. So I said, the Section 427 of the Bank Act, is that a penal section? And he said, I'm sorry, I don't understand what you mean. I said, is that a punishment, like criminal law, right? And he said, well, it would appear to me. And I said, no, is it or isn't it? It's either, is there a punishment? Is there a fine? Well, yes, there is. And shouldn't statutes that have a punishment, a penal nature to it, shouldn't they receive a literal interpretation? And he said, well, some say it should and some say they don't. And I said, well, I'm not interested in what some people say. I'm asking you what you say. And he says, I obviously think it should have a wide interpretation. And then I gave him a Supreme Court of Canada decision, Supreme Court of Canada, highest court in the land, which says that if it's a penal section in a statute, i.e. a section with punishment, then it should be literally interpreted. You're driving to Capilano University to write an exam, and you're at the foot of the Lillooet Road where there's the light, and you're anxious and you're almost going to be late for the exam, and the light's turning red, green, and you're 20, 20, 25, 30, 35, 40, 45, 48, 40. Police officer pulls you over. Going to give you a speeding ticket. The speed limit's 50. I was only going 49. Yes, but you are accelerating so quickly, so you obviously would have broken the law. Should you be fined? Obviously not, because you had not broken the law. So that's why penal statutes have to have a literal interpretation. Either you went over 50 and you get a fine, or you didn't and you're acquitted. Well, he was very obfuscatious about that too. Oh, well, it's, one of those gray areas of the law. And I said, so you're saying that the Supreme Court of Canada is wrong? And, well, no, I'm not saying that. Well, what does the Supreme Court of Canada say? So, in effect, two very important sections of his affidavit were proven to be incorrect. Okay? And that means that his affidavit should carry much less weight, right? And then there was the marketing director's affidavit, and unfortunately she just had no idea what was going on. And when we questioned her, she would say one thing and then she'd contradict herself, and then we'd question her on the contradiction and she'd get confused, and at certain points she was saying things that were actually supporting my client's position. So we in effect made her affidavit completely useless. And so now we're looking pretty good. And so now there's going to be a hearing, and Richmond Savings Credit Union called up and said, are you available to do the hearing? And I said yes. And they said great. And I said no, it's in Ottawa. And I said so, and I gave them a quote of how much I thought they should pay me to do that, because I was going to have to not only do it but also take my business manager, because I needed support, right? And they were quite surprised about the amount of money, considering how much they pay on advertising. It was they shouldn't have been. But anyway, I reduced it because I really wanted to do it. So I gave them a good quote, and they said, "Oh, okay, good." And then they called me up and they said, but you don't have to go to Ottawa. We just found out that you can do it by telephone. I said, I'm sorry, I don't do trials by telephone. Simple as that. If I'm not in the courtroom and I don't see what's going on, I cannot effectively defend your case. And I said, I have no problem if you want to find another lawyer that's willing to do it by telephone. You go ahead. And they talked about it themselves and they said, oh, okay, you can do it. So my business manager and I flew back to Ottawa. Now, the nice thing about this is I mentioned that when I had my practice at home, my business manager was my wife. So we went back there, and I had drafted my summation, okay? Now, in Regina versus Dudley and Stevens, you have witnesses called, and then the trial's closed. The Crown prosecutors do their, or Crown counsel rather, do their summation, and then the defense counsel do their summation, and then the judge makes their decision. Well, in this particular situation, the judge has the affidavit evidence and has the cross-examinations of those affidavits, and so you get to the point where you just do the summations. So I had done a legal brief, which is the legal arguments for the defendant in this. And the legal brief is a misnomer because it was 35 pages long, okay, of all the things I wanted to discuss at trial. Now, there were numerous issues, so it's much more complicated than I'm giving the impression. Anyway, I had done the summation, and we went back to Ottawa, and we were in a hotel on a Friday, and the hearing was on Monday. And my business manager wife said, Peter, do your summation for me. And I said, why? I drafted it, and you vetted it, and we worked on it together. I mean, you know what's in there. And she said, no, do it for me. So I got up, and I stood there, and I said, I started off, and I'd hardly said any few words, and I hear, I went, what? And she said, if you are that dry in your presentation, the judge is going to go to sleep and won't hear what you want to say. And so I realized, yes, of course, you have to be more animated. You have to, when you make a presentation for yourself or for a product or for a court case, you have to really believe in what you're saying. And I did, but I wasn't giving that impression. And so I went over it and over it and over it with her being very critical of my performance. Couldn't fire my business manager because she's my wife, and she was very critical in the sense that she had done a lot of acting, and so she knew how to perform. So by the end of the weekend, I had worked it out so that I had a whole presentation. Monday morning, we get up and we go to the, it was supposed to be the courthouse, but they were being refurbished, and so we were in a hotel conference room. And we walked in and we sat down at our table, and we look over, and there's a telephone. So the opposition, the Canadian Bankers Association lawyer, the second largest law firm in Canada, decided that this was obviously so open and shut that they didn't have to come. They could do it by telephone. Now, Ottawa, where that law firm was, or Toronto, and that law firm was, and Ottawa, very close. You could drive, no problem. But they decided to do it by telephone. So I could just see my client saying, see if they can do it by telephone. What are we doing here? But it turned out to be very important to be there and to watch the judge's reaction. Okay? So in walks the judge, and he sits down, and he said, all right, who have we got here? And I said, Peter Holden. Actually, you say Holden, Peter J., on behalf of the defendant. And then he looked at the telephone, and the telephone said so-and-so on behalf of the opponent of the registration. And he said, all right, okay, I'll hear from the opponent first. It's like the plaintiff, so they go first. And they basically said, The Bank Act in Section 427 says you cannot use the word bank, banking, or banker, and they used the word bank, and therefore the opposition should succeed. Thank you. That was it. That was it. Didn't deal with my affidavits or their cross-examination of them or anything. And then the judge looked at me and I stood up and I started off, and my business manager slid a piece of paper over with Z on it, because I had started off and I'd fallen back into my shell. And I was not doing my client any favors. And so I thought, oh, okay, yeah, right. And so I said, my lord, you have before you the affidavit evidence of the opponent, and you'll see that the affidavit evidence of the marketing manager is of almost no use whatsoever in supporting their case. And then there is the affidavit of this lawyer. And I started going through his credentials. Senior partner, does banking law, wrote the textbook that all law schools used in the Bank Act, and I could see the judge sort of looking at me like, all right, this is the fellow who you're going to try to say I should dismiss his affidavit, and you're making him sound like, wow, this fellow has all the credentials, you can't believe it. And then I got to a certain point, and I said, and I was very animated, and I said, and so when you take the affidavit and you look at the content of that affidavit, there are 3 sections that go right to the heart of this case, and they are all false. It's very forceful. And he snapped up his head and he looked at me, and I thought to myself, okay, he hasn't even read the file. He just looked at what we had tried to file as the trademark. He had looked at the Bank Act, and he said, they can't do that. And if he'd looked at the file, it was in a very cursory manner. And so he looked at me and he said, where's that, Mr. Holden? And I said, and because my business manager is so well organized, over comes the affidavit. And I said, on page such and such, paragraph such and such, he states that this section of the Act has never been judicially interpreted, and yet if you look at my cross-examination of it and you look at the materials, you'll see that there is a case that goes to the very heart of that section. It has been judicially interpreted, and it has been judicially interpreted in favor of my client. And you could see him, and he's writing furiously. And then he said, and what's the other one? And I said, and then there's the clause on the literal interpretation, but are we firing it back and forth? Is this like, mad? No. He said, where is it? And then I tell him that, it has been judicially interpreted. And then I stop and I watch him because he's madly, furiously writing. Okay? Now I don't want to go, this section, that section, this section, and have him go, sorry, what? And then afterwards be in his chambers going, I can't read my notes. What was he talking about there? So it actually turns out that court cases are, to a certain extent, really quite boring and very difficult, because I had to be animated and charged up and say this and then wait for him to finish doing his notes, because I want to make sure he gets that down. And then when he said, okay, Mr. Holden, I have to charge in and be animated and talk about the second one, and and then wait and watch him take notes, and then charge into the third thing and wait and have him notes. And when he finished that, he said, and you have any further comments? And he started asking me questions, and I was answering them, and trying to be animated and everything. And finally, after about an hour and a half, I was exhausted. And he said, do you have any further comments, Mr. Holden? And I said, if you'll bear with me, Your Honor. And I started with my summation, and I went page by page by page, and we just waited. Because I thought, okay, I've been jumping back and forth. I don't know if I've covered everything. And there was no way I was going to say, oh, I'm fine. And then afterwards say, oh, I should have said this, And so I went right through. And I said, no, my lord, that concludes my submission. And then the strangest thing happened. He looks at the telephone and he says, any rebuttal, Madam So-and-so? And I thought, okay, here it goes. Second largest law firm in Canada, incredible credentials of lawyers, and they're just going to shred me. And the person on the other end of the line said, any rebuttal, Mrs. Holta? No, my lord, I guess not. And to emphasize it, I went, and I looked at the phone, and then I looked back at the judge to emphasize that if they don't rebut what I said, then that becomes unrefuted evidence. So that was over, and the judge said that he was going to reserve his judgment, which means he was going to go and he was going to write a written judgment and give it later. And the reason for that is it was so complex and there were so many issues that he couldn't just give a judgment off the top of his head like happens in small claims court all the time. So, we were packing up and getting ready to go, and because it was not a regular courtroom, the judge usually leaves through a special door, and then, everyone else goes out the front door. Well, we wound up going out the same door, and I looked at him and I wanted to say, well, do I have a shot? Might I win? But you can't do that. And so I just said, my lord, do you have any idea when we might expect to receive the judgment? And he looked at me and he smiled and he said, Mr. Holden, you've given me a lot to think about. So anyway, the whole point of my explaining that is that you have to be watching the judge's reaction. And so if any of you have been in court, you've probably found in most cases they're quite boring because you ask your question and you never ask a question that you do not already know the answer to, and then you wait until the judge has completely finished writing down everything you want them to, and then you move on. So this interaction is important. Now, how does that relate to Regina versus Dudley and Stevens? Well, the judge is asking questions and he's making notes and he's showing a great deal of sympathy towards Regina versus Dudley and Stevens. So the Crown Counsel, who are trying to convict Dudley and Stevens, they're not snoozing. They're watching and they're going, whoa, wait a minute. We're at risk of losing this. They thought it was a slam dunk, just like the Canadian Bankers Association lawyer thought that their case was a slam dunk. And so, mind you, the Crown prosecutors in England didn't think it was a slam dunk because they didn't have basketball in those days. But they thought it was an open and shut case, and so all they had to do was basically show up and they'd win. Now they look and they go, okay, we're losing. Why? Because the defense counsel was bringing up this argument that here are these people on this life raft in the South Atlantic. Why should the law of England apply to a life raft thousands of miles away? There was some connection. They were English sailors. It was an Australian yacht, which was a part of the English Empire, and they were rescued by an English ship that brought them back to England. But at the time that they made that decision to kill the boy and feed upon his body, why should the English law apply? And why couldn't these people use this concept of positive law as opposed to natural law? Natural law says thou shalt not kill, and the law of England says thou shalt not kill. But why couldn't they say, well, positive law allows these individuals to make up the laws that will govern their small society? Okay, and the law of necessity is that we kill the boy because it's necessary for the rest of us to survive. So there's these two philosophical sources of law. There's natural justice, or natural law. And we can see natural law in in the legal systems. For example, in the United States, in their Declaration of Independence back in 17. I can't remember when it was signed because it was the Revolution, and then it was the Declaration of Independence was signed somewhat later. But anyway, in there it says, we hold these truths to be self-evident, that all men are created equal and are endowed by their Creator, God, with certain unalienable rights, among these life, liberty, and the pursuit of happiness. So you have this belief that all you have to do is look around and you'll know what law God meant to apply to us. Well, that's okay to a certain degree. But you can run into some little difficulties there because, for example, you look around and the laws that govern us, the law of energy, that energy can neither be created nor destroyed, or the law of gravity are there, and you just look around and you can discern them. So you can look around and you can find justice, the laws of justice to apply to us. That's great. Philosophical argument is fine to an extent, but what happens in England when the King of England gets married to a woman who cannot give him a male heir? And England was Roman Catholic jurisdiction. Roman Catholic law says no divorce. Now the king wants to divorce this woman. So what's he do? He says, well, okay, by royal proclamation, England no longer follows Roman Catholic religion. We follow the Protestant religion. So he adopted the concept of Protestant religion from Germany. And, hey, the Protestant religion allows me to divorce, so I divorce you. Well, if you look around and you find what laws God intended to apply, how can God say you cannot get divorced and the same God say you can? Okay, so the natural law develops sort of two branches: the one way only, and then one that said that you discern principles of justice to govern you, and that God will guide you in those. But natural law says you just look around to see what the laws are. That's what's in the American Declaration of Independence. Okay, that's 1776, but let's bring it home to Canada. In 1982, we repatriated our Constitution, and in the Constitution it says that it acknowledges the supremacy of God. Natural law, again, you can see how it applies and influences our legal systems. But then there's this other whole branch of philosophy that says legal positivism makes more sense, because what legal positivism does is it allows for a situation where, for example, the United Kingdom begins having its huge empire around the world and comes upon societies, African societies and Pacific islands, where there is some law-like regime but no recognizable God. Like, they had pagan gods, they had statues and things, but that isn't really God. So how can they have laws if without reference to God? And legal positivism says that laws come from a person or a group of persons who have authority over society. So that covers a situation where you have a dictatorship. A person makes all the laws, China, Mao Zedong in his little red book. And it also covers situations like the United Kingdom, where you have the House of Commons making laws. These people have the right to make laws for their whole society. So legal positivism is what the Defense Counsel was saying, that these people were not in England, so they should be entitled to use legal positivism to develop a system of decision-making to govern themselves. It would have been an open and shut case had that life raft been registered to England, because then anything that happened to the life raft would be governed by English law. But back in 1884, they hadn't thought about that. Ships were registered, but life rafts, not registered. Now, if you go on a cruise, of course you don't want to with the COVID-19 outbreak, but before that, just before COVID-19 took off like a rocket, my wife and I went on a cruise from Fort Lauderdale to Barcelona. It was on a Royal Caribbean cruise ship, and it was registered in a certain jurisdiction in the world, usually for tax purposes, Mordovia or someplace like that. And each life raft is now also registered to that jurisdiction. So had that been the case in England, then that argument would not have worked. But because the life raft was just so small and it was like a log that you're holding on to, so it could not be construed as English soil, and so they had the right, supposedly, to make up their own laws, according to defense counsel. The judge was very interested in that. Crown counsel, watching the judge's reaction, go, uh-oh, we got to do something about that. That phone in We're Not a Bank, We're Better case that I was doing, that lawyer could not watch the judge and how enthusiastically he was taking notes about the arguments I was making. So you have to be there. You have to watch. Crown prosecutor sees the judge very sympathetic to Regina versus Dudley and Stevens, so they rush out to the law library and they look for precedent, another court case which will help their position, and they find one. Just a few years earlier, what had happened was a English merchant ship had gone to the West Indies, which is just the Caribbean area, and they had filled up with all that good stuff, rum and tobacco, and had turned around. They were heading back to England when a French frigate bumped into them. In those days, you didn't have radar. Beep, beep. Oh, we got a contact. Let's go investigate. No, you just sailed around and hoped you bump into people. So the French frigate sees the English merchant ship. They fire their cannon. Boom, boom. And they're going to take the merchant ship captive, take it back to France, change the registration, plunder the goods. I don't know what happens to the crew. I don't want to know. But anyway, bad luck for the French frigate. 2 English frigates are close by, and they boom, boom. They go, that's not thunder. There's no clouds. Let's go investigate. So they come and they capture the French frigate and bring the French frigate and the merchant ship all back to England. The French sea captain is put on trial for piracy. Well, the laws of England were designed and written to punish pirates, English pirates. Okay, so the judge in that case looks at Crown prosecutor or Crown counsel and says, why should the laws of England apply on the high seas to convict a French sea captain of piracy? Without missing a beat, Crown counsel pops to his feet and he says, well, my lord, the Queen said so. And the judge says, the Queen said so? In high school, we used to spend a lot of time looking at English history because so much of the development of Canada stems from that. Nowadays, it seems as though the shift is towards studying a lot about our native people, to the detriment, I think, of this particular story, because Queen Victoria at that time had made a famous speech that we had always talked about in high school. And in that speech, she said, England rules the waves. Okay? And the Crown prosecutor said, or Crown counsel said, my lord, what else could Queen Victoria have meant by that statement that wherever England can enforce its laws on the high seas, English law applies? Now, in that case, the judge wanted to find the French sea captain guilty. So he was very quick to say, guilty, and they took the French sea captain and hanged him by his neck until he was dead. So, in summation, the Crown prosecutor, I keep calling prosecutor, that's U.S., Crown counsel, stood up and did a summation, said the law of England says if you kill someone, it's murder, and you shall be taken from this place of justice to a place of execution and hanged by your neck until you are dead. And there is precedent for that law, and they provided the judge that case. The judge read that case, and when he made his judgment, he looked right at defense counsel, and he said, I feel constrained by precedent to find Messrs. Dudley and Stevens guilty of murder. They should be taken from this place of justice to a place of execution and hanged by their neck until they are dead. And he looked right at them and he said, this is the law. This is not just. What did he mean? Well, let's change the law. It took years to change the law. And even if they did, it wouldn't be applied retroactively. And besides, Messrs. Dudley and Stevens would already be dead. Why? Because you went to death row not for years and years and years until finally they execute you. No, you lasted as long as it took them to build a gallows. So everybody that was hanged, apparently they had to have a new gallows for everybody. So they build a gallows, bing, out there, you're hung, or hanged. So the prospect of changing the law was of no help. Appeal? Well, contrary to popular belief, you can only appeal if you have grounds for an appeal. And the law was so clear, an appeal was not possible. And thirdly, the reason he said that was because there is something you can do, but let's do it this way. In all those old movies, old U.S. movies where someone's on death row and they're taking him out to put him to death. Dun, 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 dun. And you always see somebody with his hand on the phone. Okay. What's he waiting for? Hi, Mom, coming home late today because we're hanging somebody? No, what he's doing is he's waiting for a call from the governor. Hi, yes, commute the sentence, all right. And they would stop the execution. Well, that doesn't happen in England because there's no governor. Okay, so who is he suggesting the defense counsel contact? The Queen. And we know this because there was a lot of media attention. So anyway, the defense counsel wrote out a letter outlining what had happened. They ran down to Buckingham Palace, knocked on the door, and they hand it to the person that answers the door, the butler or whatever they call him. And anyway, the guy, this is for the Queen. He says, thank you. We have been expecting this. Why? Well, just before the judgment was handed down, Queen Victoria called up the Admiral of the Fleet. Oh, I say, Admiral, we have not had tea for quite some time. How would you like to drop by? No. Obviously, she called him because she wanted his counsel as to what she should do when she received this plea for clemency. And what happened was the Queen said, okay, we're not going to put these gentlemen to death, but what? Life imprisonment? Well, that would be no better than death because their families would still be at risk and they're going to die. So let them go completely? No, in fact not, because that would be flying in the face of the law, and the Queen didn't think she could do that. So she said, I think it was 6 months. Why 6 months? That seems light. Well, if you had a conviction for over a year in jail in those days, the odds are you wouldn't come out alive. You would not come out alive. It was hard and cruel punishment in jail. And so 6 months would provide them an opportunity to actually survive and yet would not fly in the face of the law. So that's what she did. Now, the third person that fed upon the body of the boy but was not involved in the killing was not charged with an offense. Why? Well, because in those days, in 1884, there was one section in the criminal code that says if you killed someone, it was murder. There was nothing that said you have to come to the defense of anyone. There still isn't that. And there was nothing else that said, okay, you cannot eat somebody, all right? Nowadays, we have a section in our criminal code which says you should not desecrate human remains, okay? And that came into play with a case where some Canadian soccer players went down to South America to play soccer, and the plane flying back over the Andes crashed in a snowstorm, and a lot of people survived, a lot were killed, a lot of people survived, but the rescue attempt was going to take a long time because of the storm. The people that survived ate the bodies of the people that had died to survive. And when they were rescued and brought back to Canada, they were charged under the criminal code for desecration of human remains. They didn't kill anybody, so they weren't charged with murder or manslaughter or anything, but they were charged with desecration of human remains. Something interesting about our court system is that the Crown Counsel has a great deal of discretion. Okay, so when a charge comes forward, this helps with young offenders. A charge comes forward, and the circumstances are such that this is the first offense, and the kid got involved in something he shouldn't have, and they can actually divert them out of the criminal code system and deal with them separately. Or they come forward and they go, okay, here's somebody that should go to trial and hopefully be convicted, but we don't have enough evidence yet. We're still gathering evidence. Let's stay this matter, which means they just put it on the shelf and they wait until further evidence is garnered. Then they bring it forward. Well, in this particular point, the Crown Counsel took the charge and said, we should stay this matter. And he dropped it in the garbage can. And somebody else said, but that's the garbage. And he said, that's where it should go. So he had no intention of ever bringing it forward, because he said those people had already been traumatized. A lot of them were undergoing a psychiatric treatment. They had already been punished enough for what had happened that there was no way he was going to take them to court. All right, so that's that. A couple of other aspects about court cases. The trial starts off with the Crown Counsel trying to prove their case, defense counsel defending against it. When they're finished with their witnesses and questioning and everything, then the Crown Counsel does their summation, and then the defense counsel does their summation, and then the trial is actually over, and the judge at that point must charge the jury. Charge! No, that's not what I mean. Charging the jury is the job of the judge to explain the facts of the case that the jury can rely on, and then explain the law. Oh, wait a minute. The facts are the facts. Yeah, except that the facts of the case, when you watch it on TV, you see the murder happen, and then you see the trial and the facts come out. But in actual life situations, the judge has no idea what happened. Okay? And so has to rely on the testimony of people and the cross-examinations, and then has to sift through all that, figure out what the facts are, and make a decision. Well, if there's a jury, the jury is going to get really confused as to what facts are facts and what facts are unproven, but claimed by one side, or as Trump says, what alternative facts. Anyway, so the judge has to decide, and when the judge has decided what they are, he charges the jury, which means he explains to the jury what facts they can rely on, and then what the law is. So in Dudley versus Stevens, the facts are outlined in the particular handout that I gave you, and then the law is very simple. If you kill someone, it's murder. Okay, and if you find them guilty, they're taken from the place of execution, or justice to a place of execution, and hanged by the neck until they're dead. There's no leniency. There's no let's reduce the charge to manslaughter. Let's say yes, they're guilty, but give them life imprisonment. There was none of that available. It was, you're guilty, you're hanged. You're not guilty, you're acquitted, and you leave. Okay, and so that's what happens when the jury is charged. In another court case that I was involved in, I had a really good business client who had renovations done to his house, and I wasn't involved in the contract or anything. But after the renovations were done, my client finds out that the contractor had done a whole bunch of extra work which had not been authorized, and wanted to charge my client an extra $10,000, and had done a whole bunch of things wrong. My client tends to be a nice guy. As I mentioned, I'm very fortunate that I can have clients that I like. So he just said, look, here's what you said you were going to charge me, nothing for the extras. Go away, I'll fix everything else myself. So my client spent about $11,000 doing the repairs to the things that the contractor did wrong. Then the contractor sues him because he wants that $10,000 extra. So he sued him in small claims court for $10,000. My client came to me and he said, look, I wasn't going to do anything about this, but now that he's suing me, I want to sue him for the $11,000 that I had to pay to fix all his mistakes. And he said, that makes it a $20,000 trial for me, because at small claims court at that time, the limit that you could sue for was $10,000. Okay. Now, it then went up to $20,000 and $25,000, and now I'm going to have to check because there was some thought about making it $50,000. But at that time, it was $10,000. So the contractor was suing for 10, and my client said, I want to sue for my 11. So what you have to do is forego the 1,000 and just sue for 10. My client said, that's a $20,000 trial, so I'll pay you to do it for me, which is pretty unusual because the legal expenses are so high that if I prepare for the trial, then he's going to pay me so much he wouldn't get his money anyway. But he said he did not want this fellow getting away with this. So I did the small claims court trial for him, and it was pretty easy to say that the contractor should not be paid for extra things that he did and did not ask if my client wanted it done and was willing to pay for it. So the judge quickly dismissed that. And then when my client was listing all the things that he had done, I was giving him invoices and having them put in as exhibits for the trial. And by this point, the judge had decided, let's get through with this, because she was, at that point, she knew she wasn't going to grant the extras that the contractor wanted, and was in favor of my client getting some money. So she just said, Mr. Holden, can we speed this up? Do you have a list of those? And I said, yes, I do. And she said, why don't you just hand it up to me? And I had prepared it all, actually. The exhibits all stapled together with an addition in the front that came to $11,000. And I gave it to her, and I did a very brief summation saying that the repairs were done, that she has the invoices. It came to $11,000. My client is just suing for 10. And the judge says, we'll have a short tea break. I thought she said pee break for a second. Anyway, she comes back a little while later, dismisses the claimant's case for $10,000. And then says, and as to the repairs, I find in favor of the defendant, who is then the plaintiff by way of counterclaim, to the amount of $8,000. And I thought, $8,000? It's 11. And I know I'm not supposed to say anything, but I popped to my feet anyway because this is small claims court. And I said, with respect, Your Honor in small claims court, my Lord in Supreme Court, Your Honor, the total came to $11,000. And she looked at me and she said, Mr. Holden, the trial is over. I've made my judgment. Case dismissed. And she got up and walked out. I had no idea where she got $8,000 because it came to $11,000, and I didn't add it. I got my business manager to add it because if I had added it, it would have been wrong. But it was correct. Anyway, right after that, my client comes up to me and he says, where did she get 8? And I went, I don't know. My business manager, who was in the back of the court, came out and said, where did she get 8? And I went, I don't know. I don't know. She must have looked at it and said, no, I don't think these are valid repairs or whatever. Or maybe she thought he paid too much for that work to be done. And anyway, she gave her decision. And so my client said, well, what do I do? And I said, well, you can appeal to the BC Supreme Court, and you will most likely get your additional 3. And he said, well, how much would that cost? And I said, well, Supreme Court is very complex, and I'm guessing at about $25,000 in legal fees. And he said, let me get this right. To get the money that I'm deserved, I have to appeal, and I'll get the $3,000, but I've got to pay you about $25,000 to do the appeal. And I said, yeah, that's about it. And he said, that doesn't make any sense. And that's one of the things that will crop up time and time and time again in our legal system. We have the best legal system in the whole world, I believe. However, it is fraught with inequities. A lot of time you get law, not justice. Okay? This was it. We got law, the judge's decision, not justice, the other $3,000 that my clients owed. Anyway, he was more than happy because he got $8,000 of the $11,000 for the repairs that he wasn't going to even ask for before, and he didn't have to pay the extras to the contractor. So he was happy, but it was definitely an eye-opener. Well, to bring it back again to Regina versus Dudley and Stevens, the facts of the case, as far as the judge was concerned, in my small claims court trial, was that the damages were $8,000, not $11,000. The judge's decision. So the same thing with the Regina versus Dudley and Stevens. The judge has to charge the jury and tell them what facts they can rely on. Okay. The jury's decision was unanimous in that case. In all my classes over the years, I have never had a situation where it was either unanimous guilty or unanimous not guilty. And that would be what's called a hung jury, which means that the jury could not come to a unanimous decision one way or the other, and so that means that Dudley and Stephen go free? No, they could actually be put back in jail. A new jury could be formed, and you could go through the trial again until you either got a unanimous guilty or a unanimous not guilty decision. You saw this in the Manafort trial in the United States. Paul Manafort, the campaign operative for Trump, who defrauded people out of a whole bunch of money. There was something like 14 counts that he was accused of, and he was found guilty unanimously on a number of them, and there were a few counts that the jury, one member of the jury said no, that he didn't think, or she didn't think that had been proved, and so he was found guilty of certain ones and then not guilty of others. As it turned out, he turned around and admitted his guilt in those two, so the jury was just wrong on that, but at least he was found guilty, okay? All right, so that is the Regina versus Dudley case, and I put in this cartoon that I found on the internet. It's a bit of black humor, but the next element is really talking about the development of the law between 1884 and now to to explain how law is not a static thing. It's a work in progress, and we'll have a short recess for that.